All right, Ms. Leonard, we'll call your case. This is docket 21-465 and 21-00466. That is People of State, City of Lansing versus Tabitha Leonard. It's a 15th, right? Will the parties please introduce themselves for the record?
Good morning, Your Honor. Assistant City Attorney Amanda Williams appearing on behalf of the City of Lansing.
Erin Robbins, Assistant Public Defender for Ms. Leonard.
And ma'am, you are Tabitha Leonard?
Yes.
All right, this is the time set. You can hear me all right, Ms. Leonard?
Yes.
This is the time set for final pretrial on two files. Ms. Williams, how are we proceeding?
Your Honor, the city moves to dismiss the two files now.
Are these, I take it these are both on a ticket? Yes.
They
they are.
are,
Yeah,
yes.
okay. All right, so Ms. Leonard, the city has moved to dismiss both tickets, both sections of the ticket without prejudice, which means that they could reissue if they choose. But for our purpose today, the case is dismissed. All right, ma'am?
Okay, thank you.
All right. Anything else, Ms. Williams, on docket 21-00465 and 466?
No, Your Honor, thank you.
Ms. Robinson?
No, Your Honor, thank you.
All right, thank you. That's all for the record in that file, in those two files. You're free to leave the Zoom courtroom. Thank you for your appearance today, Ms. Leonard.
Thank you.
Wait, 8:45 on that one. We have what left you case, so heading 2023. And Mr. Smith, are you ready on the Eddington matter?
I am, Your Honor. It's really just a control date for documents, but maybe if you gave us a breakout room, Miss Eddington and I could just straighten this out and wrap up.
All right. Ms. Eddington, are you amenable to speaking with Mr. Smith concerning this case? Put you in a breakout room and then we'll just call the case when we go back on the record.
Okay.
All right, I'm gonna have Mr. Smith and Miss Eddington placed in a breakout room.
Thank you, Your Honor.
So you should get a prompt, Miss Eddington, indicating to go to the room. Mr. Brown, are you ready to go on the Jamie Hughes case?
I am, Your Honor.
All right. Let me grab that file.
Thank you.
14. There we go. So we're on the record in docket 14-04313. That is RAZ Holdings LLC versus Jamie Hughes. Will the parties please introduce themselves for the record?
Yes, good morning, Your Honor. Attorney Chris Brown representing plaintiff.
I'm Jamie. Well, it's telling now, but Jamie Hughes.
All right, this is the time set for an objection in regards to an income tax matter. There's an order on objections to garnishment. This was filed by yourself, Ms. Hughes, is that correct?
Yes, Your Honor.
Okay, and have you had the opportunity to speak to Mr. Brown about this case, or did you want to go right into argument?
I've tried calling. I think we've played phone tag a couple of times back and forth. So, and I even tried going there. So that's why I just did the order.
Mr. Brown, would you like the opportunity to speak with Ms. Hughes, or did you want to go right to your response to the objection?
Sure, we can talk real quick, please.
All right, I'm going to have Ms. Hughes and Mr. Brown placed in a breakout room.
Thank you, Your Honor.
Thank you.
Thank you. All right, Mr. Smith, you're back on docket. So we'll call to the record docket 16-02033. That's Lapque versus Shelby Eddington. Your appearances for the record?
For plaintiff Lapque Smith, P48259. Good morning, Your Honor.
Good morning. Ma'am, you are Shelby Eddington?
Yes,
All right. And you can hear me all right, Miss Eddington?
yes, I can.
All right, I have it set today, docket 16-02033 for a show cause. Mr. Smith, how would you like to proceed? I think we set it for control date. I think you're right.
Yeah, no, it was a control date for documents. Ms. Eddington and I had a chance to speak in a breakout room. She and I have everything straightened out, and we can consider the examination complete at this point, Your Honor.
All right. All right. What is the next date you're seeking, Mr. Smith?
No date. The creditor examination, this was a follow-up to the creditor examination on the original subpoena. So at this point, we've straightened out our differences regarding documents. I would consider the creditor examination complete. We don't need any type of control date or follow-up date.
All right. Anything else for the record, Mr. Smith, on docket 16-02033?
Nothing, Your Honor.
Ms. Eddington, do you have any questions of me?
No, Your Honor.
All right, that's all for the record, 16-02033. And then, so that is towards Miss Eddington. I don't know if Mr. Beal, well, we'll call that case in a second. So that's all for the record in that file. Thank you for your appearance today, ma'am.
Thank you.
Thank you, Shelby. Have a good week.
You too, bye.
Miss Pacino. What's the second one?
Mr. Thurber.
Oh, okay, no. I had Smith on another one. That's why I wanted it. Because I have him on laugh queue, Robert Beals and Jessica Jones. All right, Miss Pacino. All right, you can come up here. Go and have a seat, ma'am. And Mr. Sasson, you're here on Miss Pacino's case, is that correct?
I am, Your Honor. Yes, good morning.
All right, we're on the record in docket 12-02493. That is John Pavlik versus Cassandra Pacino. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Christopher Sosson, spelled S-O-S-S-O-N-G, P59383, appearing on behalf of the plaintiff.
All right. And ma'am, you are Cassandra Pacino?
Yes.
All right. And this is the time set for an objection to garnishment that was filed by yourself, Ms. Pacino. Is that correct?
Yes.
Okay. Have you had the opportunity to speak to Mr. Sasson, or are you amenable to, or did you just want to go forward with your motion in regards to the objection?
Honestly, I thought they were garnishing my wage like before, so I just didn't know if it's still correct.
All right. I don't know.
Yeah. I haven't had a chance. I just got a paper just Saturday from them.
All right.
So I didn't have any idea who I was.
So, Mr. Sasson, you're here in response to the objection that was filed. Have you had the opportunity to speak to Ms. Pacino concerning the objection?
No, Your Honor, I have not, nor do I see
Did
that.
Did you want the opportunity to speak to Ms. Pacino concerning this? We could put Ms. Pacino on an iPad and put you in a breakout room to talk to her about this objection. Ms. Pacino, would you be amenable to that?
It's not necessarily an objection. I just needed more information. I thought they garnished all my wages.
I think she filed the objection because she didn't have all the information she thought she needed.
I'd be happy to speak with her in a breakout room, and I might be able to answer her questions, and then we can go from there, certainly.
All right. So I'm gonna have my court officer place you on an iPad, and then he'll set you all up, and then we'll put you in a breakout room. All right, ma'am?
Thank you.
Okay.
Thank you, Your Honor.
Thank you. Mr. Murray, you're there on your case 22-2737.
Yes.
All right, I'll go ahead and call your case. So we're on the record in docket 22-02737 Midland Credit Management versus Bobby Murray. Will the parties please introduce themselves for the record? I don't see any representative of Midland Credit Management. Sir, you are Bobby Murray?
Yes, correct, Your Honor.
All right, and this was the time set, if I read my notes correctly, we reset this on April 12th in order to confirm an identity fraud claim that you were to establish with Midland Credit Management concerning this suit. Is that correct, sir?
Correct.
All right. Were you able to have contact with the Midland Credit Management in regards to this identity fraud management? I understand. I remember the answer to this, and the answer was that there was an identity fraud claim, and this was not your debt. Is that correct?
Yes.
All right. So, and Mr. Murray, you had the opportunity to speak with Midland Credit Management about this case?
I talked to like a collector about it and stuff, and then they kind of asked me a couple of questions on like how I was gonna go about like paying the credit. I mean, not the debt and stuff. So I like made the police report last time we had talked prior, like the next day, and then I went on the IRS thing for like a fraud protection, and then I even bought an Experian thing just so they can start checking my like credit when stuff get alarmed.
Right. And you did file a police report concerning the identity identity claim?
Yes, I did, Your Honor.
All right. Well, I don't have a representative. I remember the gentleman being here last time. I don't have him here today. I'm going to assume at this point in time, which is dangerous for me to do, that they didn't send a representative here because the case is dismissed at this point. I don't have any representative from Midland Credit, and there was some question as to whether this was this, and it sounds like you took all the steps that you were supposed to in order to claim an identity fraud, that you were the victim of identity fraud.
Right.
All right. So I'm going to indicate for the record that it's 8. This was scheduled for 8:30. It's now 8:53. It would appear the plaintiff has failed to appear. The defendant is present, or the tenant or the respondent is present. And I'm going to dismiss the case. They may reissue the case if they find that it was your debt, but at this point in time, it sounds like you took all the steps in order to protect yourself from being the crime of identity fraud. Not only that, the Experian is an extra step to protect yourself that I'm aware of. That service. So I'm gonna dismiss the case at this time.
Okay, thank you, Your Honor.
For the plaintiffs fail to appear, and you should be all set, Mr. Murray. Okay.
Okay, you have a great rest of your day.
You too. Thank you.
All right.
All right, so we're back on the record in docket 140141313. That's RAZ Holdings LLC versus Jamie Hughes. Mr. Brown, did you have the opportunity to speak with Miss Hughes in a breakout room?
I did, Your Honor, and we sort of went over all the numbers, and I believe we're in agreement that the amount that is on the original garnishment that was filed back in August is correct, which is an amount of $248.60, which basically represents interest and court costs since 2014. So we're talking about 8 years. So that's a really low amount for 8 years. So I believe she's in agreement that we are able to keep that money, and that money should be released to my client. And then as soon as we receive it, I've got her new address, but she can actually give it to the court as well, of where we'll be sending the satisfaction of judgment once the funds are received from the state treasury.
So once amount is paid, then the satisfaction will be sent?
Yes, Your Honor, both to the court and to Ms. Hughes, whose new name is, I forgot, sorry.
Miss
Last
Hughes,
name- Oh, go ahead,
what was
sorry.
your original name?
My original name is Jamie Hughes. My married name
now
is
you're
Mrs. Telling.
Okay. Sorry, Jamie Hughes is now Jamie Telling. All right, and that's your understanding that once the debt of $248 is paid, there'll be a satisfaction set, and we can take the satisfaction sent, and we'll place the actual new address on the record so everybody has it. Is that right, Ms. Hughes?
Yes, Your Honor.
And what is that? Is the new address the 5171 West Centerline Road address?
Yes.
All right, so we'll place that on the record that the address is 5171 West Centerline Road, St. John's, 48879, and the correct number is 989-640-7712.
Yes.
Is that correct? All right. And then so for our purposes today, Ms. Telling, are you going to withdraw your motion to object and then proceed as indicated? All right.
Yep.
So the motion to object to garnishment is withdrawn. Is withdrawn. And then the court, once the small debt is paid, the court will await the satisfaction. Is that correct, Mr. Brown?
Yes, and I believe there's a disclosure in the file for that $248.60. So the money will be coming straight from the Department of Treasury.
All right. All right. Anything else for the record, Mr. Brown, on docket 1404313? All right, Ms. Hughes, do you have any questions of me?
No, Your Honor.
All right, you should be all set. That's all for the record in 1404313. Thank you for your appearance today.
Thank you.
Thank you, Your Honor.
You're welcome.
Hello?
Sir Michael Sefton, what case are you here on?
I apologize, Your Honor. I got the wrong Zoom number. I'm here on Bobby Murray versus Midland Funding versus Bobby Murray, and apparently they gave me an incorrect Zoom number, which I've been trying to scramble for the last half an hour to correct.
We just call that case. That case is, so you're representing Midland Credit Management, and that was an 830 case?
Yes, Your Honor. And all I wanted
Yeah,
to
I
do
think that,
all I wanted to do is ask for 60 days of discovery because apparently there's some confusion in a fraud claim, and I do apologize very much.
yeah, there's no worries. It's just that Mr. Murray was here and we
Yeah.
called that case. He indicated that he filed a police report that he was, I can tell you what he said on the record, that he
Yeah,
was.
I read his answer, Your Honor.
Right.
And all
He supplemented that since then, sir.
Oh, he did. Okay, I'm sorry. I'll shut
Yeah.
up.
Yeah, so he indicated that he had filed a police report and he had filed a report with Experian concerning the crime victims being a victim of identity fraud. At that
Okay.
point in time, and I had reset it for a kind of a control date in regards to making sure that he had come up with enough information to share with
Okay.
you. So at that time, I think we set it for. I think the case is dismissed at this point, although you could file a motion to reissue the case or to put that aside. But for plaintiffs failed to appear.
I'm sorry.
I understand that happens.
Well, unfortunately, it was a combination of errors, and one of them might be my own. I've been sitting here quietly in Judge Marble's courtroom, and they finally let me in, and they said, "Oh, you're in the, we don't have that case." So I was over in Genesee, whatever, it's like that. Now I have to explain to them how they have to file a motion. All right, because I get hired to do these things and they don't like it.
Right. So if you file a motion to set aside and you make note that you did show up, you were just late because of Zoom, we can, that's easily taken care of. I do think that Mr. Murray was indicating that he's taken all the steps in regards to identity fraud. I don't know that he said that on the record, and you put in, but I'll leave that in your capable hands.
Would that be an ex parte motion, or do I have to notice that up, Your Honor?
It's an ex parte. I think it is a regular notice of hearing that you have to send to him and the court in order to set that up.
Shoot. All right. Thank you, Your Honor.
All right. Thank you.
Yep. Bye. Come on.
Ms. Esquivel, your attorney is meeting with some other clients, and then we'll call your case. All right, ma'am?
Okay, thank you, sir.
Trying to hear.
Ms. Reed, you're here for your 9:30, is that correct?
Yes, sir.
All right, we've got some cases to call in front of you, but you're in the right place, stand by.
Okay.
And then Mr. Sassung, you're, I don't see Miss Pierce. Let's see if I can bring her back. Did she leave? She might have left.
I don't know.
Oh, that's
I believe
right, she's here.
on the iPad,
You're
Your
right,
Honor.
she's here in person. All right, we'll grab her and bring her back in, and then we'll put it on the record.
Thank you, Your Honor.
You're welcome. Sir, on Teresa's iPhone, would you please identify yourself?
Damien Brown.
All right, Mr. Brown, you're here for your 9:30?
Yeah.
All right, stand by, you're in the right place.
That's my case. I'll happen to Zoom.
All right. Mr. Brown, we're gonna place you in a breakout room with your public defender when she joins the room, okay?
Okay, done.
All right, we're on the record in docket, back on the record in docket 1202493. That's John Pavlik versus Cassandra Pacino. And Mr. Sassong, you're here for Mr. Pavlik, is that correct? Oh, we lost Mr. Sassong. Mr. Sassong, are you there? Stand by, Ms. Pacino, and we'll.
Okay.
All right, Mr. Sassong, are you ready to proceed?
Yes, Your Honor. Thank you.
All right, so we're back on the record 1202493. Mr. Sassong, did you have the opportunity to speak on behalf of Mr. Pavlik to Ms. Pacino?
Yes, Your Honor. I did.
And what came out of that meeting?
Well, Your Honor, I was able to speak with the defendant to explain just procedurally the history of this case that led to the writ for periodic garnishment. It is plaintiff's position, but we were unable to resolve the
All right,
pending.
so I'll let Ms. Pacino go on with her motion and then you can respond. Ms.
Thank you.
Pacino, so you want to continue with your objection to the garnishment?
I really just wanted to lower it. That was it. I didn't realize I remember going to court for him and I remember being garnished.
Okay, what's the total amount due at this point?
He said it was 4,000. And he said that he had no payments, which I remember going to court and I remember them garnished. That was what we went to court for. So I was just confused. That was all. Is from 2012 until now, I've worked several places and I thought that once it was a garnishment, it was out of my hand, that you guys would just take it whenever you That's what I was understanding. I'll pay it. It's fine. I just can't afford that amount. that they're
So
paying.
what's the total amount right now that you, that's your understanding the amount due?
Your Honor, I'm sorry.
Go ahead.
The current judgment balance, Your Honor, is $5,951.83.
All right. And then what is the current garnishment amount?
Our office, I don't know the answer to that question, Your Honor, because the defendant filed this objection and the garnishee is withholding those withholding payments pending the court's decision on this objection to garnishment.
So what is the garnishment amount that you say you cannot afford?
I was told that it was 20%. I don't remember even where I got that number from. I just $250 is what I was told from. I mean, up until I heard.
I don't think that they've ever.
See, that's again,
I don't have it as.
I mean, he can take $100 on every check. $250. That's, I get paid every 2 weeks. I didn't know that I was able to make that, but I don't have a problem.
So you don't have an amount that you're objecting to the garnishment because I don't have that you've ever made a payment on it.
See, and that's the John Pavlik is the only one that I went to court for. And I specifically remember them changing the amount because he was trying to charge $50 a day. So I thought the garnishment just automatically came out. I didn't know that I had to put effort into it. I don't know.
Okay. And Your Honor, just procedurally here, a money judgment was entered in this summary proceeding on July 13th of 2012 in the amount of $4,836.14. Right. There were no post-judgment payments received to date. And subsequently, prior to the expiration of the initial judgment, plaintiff had petitioned to renew the judgment, and that was granted by the court on June 14th of 2022. And the judgment renewed in the amount on that date in the amount of $5,668.49. Again, there were no payments whatsoever received prior to the renewal. Subsequent to the renewal, this writ for periodic garnishment was sought and issued. And as the writ indicates as well, through the date of the issuance, the date that the writ was sought, there were 0 post-judgment payments made to date. The amount of the unsatisfied judgment as set forth in the writ dated February 28th of 2023 is $5,895. It sets forth, of course, the post-judgment interest accrued to date, as well as post-judgment costs to arrive at the amount of $5,895.90. And as I indicated to Your Honor earlier, this writ, there have been no withholding payments sent to our office to date because of the defendant's objection. So I don't know what amount is. Right. The maximum, of course, 25% based on her wages would be withheld. But again, I don't know what that amount is since they're being withheld. If the defendant is seeking an installment payment plan, it is plaintiff's position that this an objection to the garnishment is improper. As it is plaintiff's position, the judgment balance is accurate, it is correct, and she's failed to set forth a valid basis for the objection to the garnishment pursuant to MCR 3.101K2. And she would need to file the appropriate motion for installment payments if that is essentially what she's seeking here today.
So if pursuant to statute, a 25% garnishment you have no idea what the garnishment, you just filed an objection.
Yeah, I didn't know. They said that if I did that, then I could address
Who's
that.
they?
When I went up to the civil court, they just gave me my option, and maybe I misunderstood them as, but I specifically asked if I did this way, would I be
So a
able to?
25% garnishment of $5,895 would be $1,473. Is that correct, Mr. Sasan? That's what I have at 25% of 5,895. You're indicating you can't afford that.
Well, Your Honor, the 25% withholding calculation is performed each pay period. With taxes deducted, the garnishee calculation worksheet is provided to the garnishee, and that portion that up to that 25% is withheld after the garnishee performs the calculation for each pay period. So there's only a portion up to 25% that is taken from her periodic pay. In this case, the garnishee filed a disclosure indicating that payments are made bi-weekly. So each
at what amount? You don't know, right?
I don't know the answer to that question at this point. Now, if the defendant.
So what can you pay bi-weekly? You haven't paid anything.
Right. I mean, I $100, right? I mean,
So that's $200 a month.
yes, until I can, I mean, my leg is hurt. I have 2 jobs. I picked up a second one just to put my son through tutoring.
So she says she can pay $200 a month for the first, I'd say 6 months.
And possibly even sooner. Once I get back on my feet, I can pay more. I just really was misunderstood this whole time.
It's a long time to be misunderstood.
No, but that's what I said. It just, I'd worked so many
That's
jobs.
like 11 years.
That's why it threw me off. I worked in 2017 and they were garnishing my wages.
I mean, this is.
But
Evidently they weren't.
that's what I'm saying. I didn't go to court for anybody else other than John Pavlik. So that's why I assumed. So, but talking with them, and then it was just years went by and nothing. So I did assume that it was done.
All right. Well, I don't have any numbers to work from. You don't have any numbers to work from, So in that regard, I would say that that your order is just a general order to object.
I know.
But if you're telling me right now you can pay $200 a month, what I'm willing to do here is set a control date to see if Mr. Sasang is receiving his payment, and set up a plan in that way, just to make sure, because this has gone a good 10, 11 years without any payment, and I'm assuming your client would like to get something in regards to this debt.
Yes, Your Honor. My client's position, though, however, respectfully, is that it has not received any payments yet at this point. And while I understand the defendant is proposing $200 a month, I believe that the defendant would properly address an installment payment before the court by filing a motion. My client doesn't have the benefit of knowing what the defendant's income and expenses are in order to evaluate whether $200 a month is a fair proposal in light of the garnishment. She's already indicated she has a second job as well, so I don't know what her.
That I'm not working currently.
Right. Well, here's the problem: is Mr. Sasang doesn't have any numbers. I don't have any numbers, and we're kind of going in the dark here.
Yeah.
And until you come up with a motion to set aside, and then you provide us information in that regard, I have to deny your motion. Okay. So I'll deny the motion to object to garnishment.
Yeah,
because we just don't have any numbers to work from.
I know.
Deny motion to object to garnishment, and then what you can do is file a motion with the appropriate information indicating this is why I can't make this payment.
Okay.
And that gives us an opportunity to revisit this issue. Okay.
Okay.
So I'm going to deny the motion to object to garnishment. And then I'm going to indicate for my records that we'll await a new motion with some financial background. And then we'll go from there. And I think Mr. Sung is right. He can't make a decision on behalf of his client if he doesn't know what financial information you're to provide us, which is fair. Okay, that's a fair statement. So I'm going to indicate that the objections are at this point the objections are invalid. And so it remains a collections issue, but you should file a motion in regards to giving us some financial information so we can revisit the issue, okay? All right. Anything else for the record? Docket 1202493, Mr. Sasan.
No, Your Honor, nothing for plaintiff. Thank you.
All right, thank you. You're all set, ma'am. We'll await your motion with some financial background, okay?
Okay, thank you. I'll work with that right now.
Thank you, Your Honor. Have a good day.
You too.
Thank you.
I'm gonna put that left. 16046. Oh, I don't have all the stuff. All right, Mr. Brown, we'll call your case. This is docket 23-01130. That is City of Lansing versus Damien Brown. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Assistant City Attorney Amanda Williams appearing on behalf of the City of Lansing.
Aaron Robinson, Assistant Public Defender for Mr. Brown.
And you are Damien Brown, sir?
Yes, sir.
And you can hear me all right, Mr. Brown?
Yes, sir.
Okay, this is the time set for a pretrial in the matter. Ms. Williams, how are we proceeding?
Your Honor, would like to request an adjournment for 2 weeks for compliance purposes.
And is that a correct statement, Ms. Robinson?
It is.
That is both on the file and the underlying ticket, correct?
Yes, Your Honor.
Yeah.
All right, date.
June 5th at 9.
June 5th at 9 o'clock. It was weird to see things June. All right, we've reset this matter for June 5th at 9 o'clock, Mr. Brown. This is reset for June 5th at 9 o'clock for your compliance. So please keep in contact with your attorney, Ms. Robinson, and make sure you come to court or have at least provided anything that's necessary. All right, sir?
Yes, sir.
All right. Anything else for the record in docket 23-01130 or the accompanying ticket, Ms. Williams?
No, Your Honor, thank you.
Ms. Robinson?
No, Your Honor, thank you.
Thank you. That's all for the record in that file. Mr. Brown, you're free to leave the Zoom courtroom. Thank you for your appearance today.
Thanks.
Is there a Quantrell Lake
Here.
All right.
Yeah.
All right. And Mr. Lake, I don't have you represented today. Are you represented by counsel?
I have Ms. Sutter.
You have Ms. Sutter? I've just been made aware that Ms. Sutter is your public defender.
Yes.
All right. Stand by. You're in the right courtroom, sir.
I'll talk to him.
All right.
Breakout room, please.
All right, Mr. Lake, we're going to place you in a breakout room with a public defender. so that you can speak to the public defender, okay? You're,
Okay, that's fine.
all right. All right, so we're on the record in, let me grab that file. I don't have that file yet. Hanley. I don't have that file. For some maybe it's over here. 918. All right. All right, so we're on the record in docket 23-00918. That's Winton Payne versus Tiffany Hill. First is temporary, one is judgment. All right. So I do have a first is temporary. Will the parties please identify themselves for the record? So say it again.
Mackenzie Payne Winton.
Okay.
Tiffany Hill.
Okay, so if I remember correctly, last time there was an indication of a oral order to the court that the subject matter of the claim and delivery should be delivered to, and you're going to go to the house, and then there's an indication that the person wouldn't provide the dog over.
I took her to the house after court that day and we contacted the police department. We were there for probably an hour.
The
police said we had to leave the premises. The cops told us to leave the premises and that we had to get an order from you.
Right. So I'm in possession of an order right now.
Okay.
Okay. So this is done. This looks like it came from our civil department. You did not. You did. This would be your order. All right. Did they provide you with an order or did they just,
They just said it was a civil matter. and to
okay.
Get back.
But it is yours, but it's your civil matter because you're suing, right? So just be aware that if you're requesting something for the court to act on it, it's got to come from you, all right? But I have here I have a judgment claim and delivery. I have, for the record, I have 2 orders. First is temporary and then the one is temporary, one is judgment, okay? And I don't know what that means, except that I just want the dog to be taken out of. So if you need law enforcement involved, there should be an order, okay? And at this point in time, that individual is not willing to give you possession of the animal, correct?
Correct.
All right.
So I didn't know what route to take that day.
Yeah, I completely understand it.
Okay.
Yeah, and I completely understand law enforcement saying, unless there's something in writing, we don't want to go over there and grab the dog, okay?
Right.
So the court finds, so there's the judgment. Court finds the party is entitled to possession. And I'm going to indicate that you are, ma'am. Okay. You are the party of record, although, I mean, so this applies to you. You know, so I think it's a good idea that you're both going over there.
Yeah,
Because you still are the party of record. It's just that you've given possession to somebody
correct.
and that person won't give it back to you.
I was more than willing to go with
Okay.
her, and I'll go again today if she would like, with an order, so that.
And this is pursuant to consent. You're saying this is you want the dog back to Miss
Yes.
Payne,
Correct.
just to get essentially to kind of get you off the hook.
Will that give us, if we go there again today?
It should.
Okay, because we were there for over an hour on a front porch.
I mean, if you have to get law enforcement, I'm going to sign this today.
Okay, thank you.
So this is a consent judgment. The following describe the property for me.
English Bulldog?
Just pulled up. And what's the name?
Dior. But they named her Fergie.
Yeah.
Fergie or Dior.
Fergie. I'm going to put them both.
I mean, I named her Dior, but I guess they
Right.
renamed her.
Maybe a color.
Okay, this judgment is granted on today's date, May 15th.
She's Murrah as well. I don't know if you need a
color so
color
that
or
they
whatever.
can.
A Murrah.
Yep.
Let's see.
Spotted.
So spotted. English Bulldog. You're gonna know the dog when you see it.
I seen her when
We
we pulled
seen
up.
it already.
Okay. So this is signed on May 5th, May 15th, today's date. Let me. 5/15/2023. All right, so I've signed the judgment and claim of delivery. This should answer any questions. I'll go ahead. The court finds the defendant has possession of the following described. So let's go ahead and make them both. So a Murrah spotted.
Female English Bulldog.
Murrah spotted. Female.
Yeah.
We're going to provide you with a copy of it.
I was asking if she would like to go today. After
Yeah.
this.
Bulldog. And the dog goes by, I'm going to put all the names down. It goes by Dior, or
Fergie.
Fergie. So at this point in time, I'm going to have So I'm gonna have you. I'm gonna have it to you to retain possession of the property and restrain it from damaging the property in any way. And then I'm gonna go ahead and indicate that the sheriff or court, if necessary, shall seize the described property and deliver it to you, okay? Since we seem to have some reluctance to follow the instructions. Sign. If the sheriff has any answers, have him contact them. You'll get a copy of this. The
Okay.
original's in the file. Ms. Hill, go ahead.
Would you like the would it help if you put the address of where it's at? So
Sure.
then that would help the officer too.
Address.
658 West Vermontville Highway. Potterville. And then I don't know if you want the name as well to put on there of the individual.
And then the name of the person holding dog
Yes,
is what?
Lemo, Lemo.
And his last name?
Byrd, BYRD.
And then I'll put it on the order of possession too. .658 West Vermontville Highway.
Potterville, yes.
And the name is Lemo Byrd. All right, so there's a court order indicating that judgment, claim, and deliver an order of possession be delivered to you. Ms. Hill, you've been very amenable in getting the dog over to the plaintiff at this point, and mostly because you're on the hook for the dog right now,
Right.
you know? So you're doing everything you're supposed to. What Mr. Byrd needs to understand is if he refuses to follow the order, law enforcement can come and take the dog based on the order. So also they can file a police report concerning stealing. Okay, because he's in possession of a dog that's not his. Like, and I think that's what he really doesn't want.
Yeah,
You know, is he doesn't want to get involved in something where he's keeping a subject to the court order. He's saying, no, I won't. And then he is converting the dog to his own use, which is a form of embezzlement.
okay.
And that's what he doesn't want.
But we tried explaining the best we could last Monday, but we weren't getting anywhere since we had no paper.
Right.
proof of
Now you have
anything.
paper.
Okay.
You have paper signed. So this shouldn't be a thing. If it is, then yeah, and the last page really is for the sheriff.
Okay,
Good
in
for-
case we have to.
Yeah, in
call them.
case we have to. But if they have any questions, they can call my staff here, all right? Because we were kind of familiar with it once he said he wasn't delivering the dog. But, you know, and then so that'll take care of the possession of the dog. So I've signed both the order. Let's go get the dog back and then we can go from there. Okay. All right. Anything else for the record in docket 23-00918, Ms. Payne Witten? Ms. Hill?
No, sir.
All right. So you can get a copy of the court order. All right. They'll provide you a copy. The original stays in the file, and then you can take that. I would start at the address and then go to the sheriff's department again with the order in hand. Okay. All
Okay,
right.
so go to the address first.
Hopefully, once he sees that it's signed, this is an easy answer. If
Okay.
not, then the sheriff has to get involved, and the response is to go to the sheriff and say, here's the order.
Okay,
You know, and then if the sheriff wants to contact our office, they can, because, you know,
we told them that last week and they just
Right.
They were actually very rude to us.
Well, I mean, without having any type of paper in hand, it's
Right.
just everybody's verbal responses to what's going on now.
Right.
But now there's, it should be the first, go ahead and give them the second one too. Yeah. Because I mean, if you're satisfied with possession, I mean, and that was your claim and delivery, we're done with the case. That'll finish up the case. So that'll be a satisfaction. If you have another civil complaint concerning any monetary damages, that might be a different issue. But this will put the dog in your hands. All
Thank
right.
you very much.
All right. Thank you. You're all set. Just if you meet, if you send back, we'll bring you a copy of the order. Okay.
Okay.
All right.
What time we work today? What time we work today? You're doing a check. Oh, tell you,
Ms. Esquivel, we're gonna call your case.
All right,
All right, so
Honor.
we're on the record. Okay, we're on the record in docket 22-03372. That's City of Lansing versus Siciliana Esquivel. Will the parties please introduce themselves for the record?
Morning, Your Honor. Assistant City Attorney Amanda Williams appearing on behalf of the City of Lansing.
Aaron Robinson, Assistant Public Defender for Ms. Esquivel.
And ma'am, you are Siciliana Esquivel?
Yes, sir.
All right, this is the time set for a pretrial in the matter. Ms. Williams, how are we proceeding?
Your Honor, the city moves to dismiss at this time.
All right, no, and I'm assuming there's no objection, Ms. Robinson?
Correct.
All right, Ms. Esquivel, this is dismissed without prejudice today, which means the city could reissue if they choose to, but for all intents purposes, the case is dismissed today. Okay, Ms. Esquivel?
All right, thank you, Your Honor. You guys enjoy your day.
All right, you too. You're free to leave the Zoom courtroom. That's all for the record, 22-03372.
All right, thank you much. Bye-bye.
Bye-bye.
Mr. Lake.
Mr. Lake, all right. Yeah, let's see. I don't have those files.
It might just be with the rest of the show cause files
That's not right, and
at the bottom.
at the bottom is there.
Oh. Which step? This one? Oh, I've got them. I've got them right here. So I also have two show cause files we can work through on Mr. Lake. All right, so we're on the record in docket 21L2671672. That's the City of Lansing versus Quantrell Lake. Will the parties please introduce themselves for the record?
Assistant City Attorney Amanda Williams appearing on behalf of the City of Lansing.
Aaron Robinson, Assistant Public Defender for Mr. Lake.
And sir, you are Quantrell Lake, and you'll have to unmute yourself.
Oh, how you doing? It's Quantrell Lake.
All right, you can hear me all right, Mr. Lake?
Yes. Can you hear me?
All right, I can, thank you. This is the time set for a pretrial in the matter on a fail to display an ops among, looks like this is the main one on the ticket. It looks like one was a waiver offense. Anyway, Ms. Williams, how are we proceeding today?
Your Honor, I'd like to request an adjournment for 30 days for compliance purposes.
All right. So the adjournment is the last one granted. Because this will put this at least 60 days on my register of actions. There was a 30-day adjournment granted on April 17th. That's your understanding, Ms. Robinson?
Yes.
All right. So we'll adjourn the matter for 30 days. This is the last adjournment, and date, please. We set for June 12th at 9 o'clock.
All right.
And please, we're gonna go ahead. We have two show cause balances, but so stay where you are, Mr. Lake. So you don't end up with another on you. But that's all for the record in 21L2671672. And then we have two show causes that have been set for, and they're both for balances. So you were show caused on May 4th, it looks like. Show cause was set for today at 11. Yep. I'm sorry, I didn't hear you. Yeah, I've got 258 and 180. So Mr. Lake, you've been show cause today for, you have a balance on one failed to yield ticket for $180. You have a balance on a no proof of insurance for $258. you need some time to make payments on those, or else you're just gonna get caught in a bench warrant cycle here if you don't continue to make payments. So altogether, you owe 258 plus 180, you owe $438 to the city of Lansing. Do you need some time to make those payments? Those been outstanding since it looks like March 24th.
Yeah, like I was explaining to my public defender, I was unemployed at the moment. I literally just started working like less than a week ago. So I have to do a week in a hole and then my 2 weeks in order for me to even get my first check.
All right, well, let's do this. Let's set it out 60 days. All right.
Yeah.
So the entire balance of 438 should be set out for 60 days. I'll give you 60 days on each to make payment, to pay that up. You can make payments however you want. You can make them as 15, 20, 25. They just
I'm trying to pay everything at one time so I can get it done and over with.
All right. As long as it's paid by 60 days. If not, they'll just show cause you again and you'll end up in front of me again or with a bench warrant. And that's what we're trying to avoid.
I got you.
All right. So July, so we'll set payments by July 14th on file 21L2671673. That's a balance of $180, and we'll set payment by July 14th at $258 on docket 21L2671671. So July 14th is the date, all right, Mr. Lake?
Yes.
All right. Do you have any questions of me?
No, sir.
Okay, you should be all set. Thank you for your appearance today.
All right, thank you. Am I good to leave the call?
Yes, you are, sir. Thank you.
All right, thank you.
Ms. Sutter, you ready on some files?
Several, Your Honor, yes.
Okay.
Mr. Thurber is here and ready to go.
All right. All right, so we're on the record. We're on the record in docket 21-02572. (21-2573), and then an accompanying ticket of 21L2653562. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Assistant City Attorney Manny Williams appearing on behalf of the City of Lansing.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter appearing on behalf of Mr. Thurber, who is standing to my right.
And sir, you are Josiah Daniel Thurber?
Correct.
Okay. This is the time set for a pretrial in the matter. Ms. Williams, how are we proceeding?
Your Honor, I will be amending the driving while license suspended, allowing a licensed person to drive.
Okay, so that's file 21-02572. Is the DWLS?
Yes, Your Honor.
Okay, and you'll be amending that. Is that a ticket? Or is that
It's a civil infraction.
is the underlying charge is a ticket, right? I have it as a ticket. Count one of a ticket. L265356. And so you're amending that to no ops in possession?
No.
No, allowing an unlicensed person to drive under MCL 257.362.
To allowing.
It's a civil infraction 0 points.
That's the final. Fine.
Okay, just a second. This, and I'm not. Wow, unlicensed driver, such a misdemeanor in their system.
There is an identical name misdemeanor. The traffic code indicates it can be a civil infraction or a misdemeanor.
All right, so we're
going for the civil infraction.
so you're looking for the civil infraction.
Yes.
In our system, it is not listed that way.
Oh.
That it can be a civil infraction.
So it's only a misdemeanor.
In our system, that's what it showed me.
257.362.
I
You definitely don't want him to have a misdemeanor if you're
That's what we're
bargaining.
trying to
Yeah,
avoid, yeah.
You're bargaining out of a misdemeanor.
There's 2 MCOs in that box.
It still shows JIS as a misdemeanor. That's why when she said it. I was
Yeah.
like, I think that's a misdemeanor.
It was a 257,325.
325.
Yes.
So look up 257.320.
It's listed under both.
325.
This is where like the traffic codes were fantastic and super helpful. So just enough for lacking information. Really annoying.
So we don't show that civil infraction.
I'll amend it to a different civil infraction.
Just
That's fine. You're
something other than it's something under the misdemeanor that you're trying to avoid, right?
Yes.
Yeah. But I'm afraid that we take the plea on a civil infraction and it still shows up as a misdemeanor.
That's what I'm afraid.
That doesn't help, Mr. Thurber.
No problems, Your Honor. I'll just amend it to impeding traffic.
Okay, I know that's a civil infraction.
Yes, that's a civil infraction.
Okay, so,
Your Honor, I will actually be amending all 3 charges to impeding traffic.
all right, so the DWLS to impeding traffic.
And no insurance and the improper plate.
Okay. And what's the number for impeding traffic?
That's MCL 257.676B.
All right. Civil infraction. And is that a 130 fine?
Yes.
Yes.
All right, and you'll be accepting responsibility on behalf of your client, Ms. Sutter?
Yes.
All right. Mr. Thurber, just so you understand what we're doing here, you have 2 files and a ticket. They're all going to be amended to the civil infraction of impeding traffic under 257.676B. So that's file 2102.573 is going to be amended to impeding traffic. 2102.572 is going to amended to civil to impeding traffic, and the improper plate portion of the ticket is going to be amended. That's 21L2653562 to impeding traffic. They all carry a $130 fine. Do you understand that, sir? And it's your wish to admit responsibility today through your attorney. Is that correct? All right. So, Ms. Sutter, do you admit responsibility on behalf of your client to each one of the impeding traffic civil infractions concerning 2102.573, 2102.572, and the accompanying ticket of 21L2653562?
I do, Your Honor.
All right, thank you. With that admission, that sets us up to $63.90. So it'll be a total cost of $390 in fines. Does your client need some time to make those payments?
Your Honor, I think he plans on paying as quickly as possible, but if we could just get 2 weeks as a
All
buffer in
right,
case.
so 2 weeks to make. So let's set it for May 29th. Oh, let's make May 30th. We don't want to put it on Memorial Day.
Thank you.
So May 30th. 2023 for $130 payment on 21-02573, May 30th, 2023 for $130 payment on 21-02572, and May 30th, 2023 on accompanying ticket of 21L2653562 for the $130 payment. So make that May 30th date set for all three, which is 390. All right. All right. Anything else for the record in either one of these dockets, which is 2572, 273, or the accompanying ticket, Miss Williams?
No, Your Honor, thank you.
Ms. Sutter?
Nothing further. Thank you.
All right, Mr. Thurber, you're all set.
Appreciate it.
Who's next, Miss Sutter?
Mr. Moorhead is ready.
All right. So we're on the record in docket 23-0015. That's City of Lansing versus Sean Moorhead. Will the parties please introduce themselves for the record?
Assistant City Attorney Amani Williams appearing on behalf of the City of Lansing.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Moorhead, who is standing to my right.
And sir, you are Sean Moorhead? All right, this is the time set for a pretrial in the matter. Ms. Williams, how are we proceeding?
Your Honor, I would like to request an adjournment for 30 days for compliance purposes.
Okay, and that's your understanding, Ms. Robinson?
It is mine.
Oh, Ms. Sutter, okay. So we've adjourned this previously for compliance on April 17th. So this is the last adjournment for compliance. I'll make a note of that. Last date. And we'll get a new date for compliance purposes in 30 days. June 12th at 9 a.m. So make sure on that date, Mr. Moorhead, you bring in whatever the city attorney requests concerning that adjournment. I've reset it for June 12th at 9 a.m. All right, sir? Anything else for the record in 23-00015, Ms. Williams?
No, Your Honor, thank you.
Ms. Sutter?
Nothing further. Thank
All
you.
right, you're all set. Thank you, sir. Reed.
Because I don't have a case file.
Ms. Rawls, you're here on Mr. Hanley's case to set aside a conviction?
Yes, I am.
All right, thank you. I'm just making sure I understand who's here. We've got a couple files, then I'll pull that file, okay, ma'am?
Okay, sounds good. Thank you so much.
All right, so we're on the record in docket 21 L2663-082. City of Lansing versus Dustin Wayne Koloski. Will the parties please introduce themselves for the record?
Your Honor, Assistant City Attorney Emmanuel Williams appearing on behalf of the City of Lansing.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Koloski, who is standing to my right.
And sir, you are Dustin Koloski?
Yes, sir.
Okay, this is the time set for a pretrial in the matter. Ms. Williams, how are we proceeding?
Your Honor, I will be amending the drove unregistered impeding traffic.
And you just gave me that site, but
That's fine. That's MCL 257.676B.
676B, it's $130 fine
Yes, Your Honor.
and no points. And is that a correct statement, Ms. Sutter? Did you need some time with your client?
I think we're okay now, Your Honor.
Okay. All right. Is that your understanding, Ms. Sutter? This is amended to a civil infraction.
Yes.
Under 257676B with a fine of $130.
Yes.
All right. And will you be admitting responsibility on behalf of your client?
I will, Your Honor.
All right. All right. So, Mr. Koloski, that's your understanding of setting pleading admitting to responsibility through your attorney, Ms. Sutter, to the civil infraction down from a misdemeanor. Is that correct?
Yes, sir.
All right. So, Ms. Sutter, just so we're making sure we're working from the same ticket. If I could speak, I would.
I've been there, Your Honor.
Oh.
You've heard me attempt English a few times.
So pursuant to ticket L266308, do you accept responsibility for the impeding traffic at King Boulevard, St. Joseph in the city of Lansing on behalf of your client?
I will, Your Honor.
All right. With that understanding, the admission of responsibility is accepted. Do you need some time to pay that $130 fine?
Yeah.
About how long do you think?
If I could get like a month or so, that
30 days?
Yeah.
All right. So 30 days to pay. What's 30 days? So Wednesday, June 14th. By 4 o'clock to the city of Lansing. That can be paid online, in person, or just right here at the window, okay? Anything else for the record in docket 21 L2663-082, Ms. Williams?
Your Honor.
Ms. Sutter?
Nothing further, Your Honor.
All right, you're all set, sir. Thank you for your appearance today.
Thank you. Thank you very much.
Did you want to go on Reed, or did you need to meet with Miss Reed?
I need to have a quick chat with her. I'm just making sure I'm not people can handle. Yes, I'll have a quick chat with her.
All right.
I think I am still in the breakout room.
I think you're in room 2. So Miss Reed, we're going to place you in breakout room 2 with your public defender, Miss Sutter, okay?
Okay.
All right, thank you.
Secretary of State filing his license currently valid, so I have no objection to that.
All right, so Mr. Hanley, are you there? Is Miss Rawls there?
Hello, Your Honor. This is Joseph Hanley. She stepped out for a brief moment. She should be right back with us.
All right, when she comes back, when we see her come back, we'll call the case. All right, sir?
Yes, Your Honor.
All right, thank you.
You're welcome.
I saw Mr. Dew and Mr. Whitty here. That's why you separated the files, Nathaniel. I get it. I got it.
What'd you say?
All right, here we go. That's where my pen went. Number 4. All right. All right, so we're on the record. This is City of Lansing versus Joseph Hanley. Will the parties please introduce themselves from the record? Ms. Williams.
Good morning, Your Honor. The City Attorney Emmanuel Williams appearing on behalf of the City of Lansing.
Good morning, Your Honor.
And go ahead.
Good morning, Your Honor. Attorney Linda Rawls.
Good morning, Joseph Hanley.
Okay, and sir, you are Joseph Hanley, and you can hear me all right, Mr. Hanley?
Correct, Your Honor.
Thank you. This is the time set for an order to the hearing on an order for application to set aside a conviction. I have the order present. The file signed to Judge Lato sunsetting of Judge Felice's docket. Judge Felice, that's interesting. I got to practice in front of Judge. It just makes me feel old. I got to practice in front of Judge Felice. Ms. Williams, any comment on the order to application to set aside the conviction?
Your Honor, no objections from the city. It looks like that Mr. Hanley's license is valid currently, and I have no objections to setting aside the conviction.
Thank you. I'm indicating that I'm looking at the order to set aside the conviction. There's an indication that the applicant has not been convicted of 3 or more felonies. These are not criminal charges. There's no criminal charges pending against the individual. And number 12 is the circumstances and behavior of the applicant from the date of the applicant's conviction to the filing of the applicant warrant setting aside the conviction and is consistent with the public welfare. With no objection, Ms. Rawls, I will check that box. Also, the opportunity has been given the Attorney General and prosecuting official to contest the application, which they did not. So I will check box 12 without objection, and I will sign the order. All right, ma'am?
Thank you, Your Honor.
Thank you. All right, so I'm signing and dating the order. Anything else for the record, Ms. Williams?
Your Honor, thank you.
Mr. Hanley, you're all set today. Thank you for your appearance.
Thank you, Your Honor. You have a good rest of your day.
You too. I need some show causes, I bet. And then I've got some.
Yeah, but this one. Here they come naked down the street.
404.
Underlying reason.
Is that a 2?
And that would not have been a good reason for the
Right, I have some here that are.
They did. Okay.
It looks like it's got enough time since we submitted to report.
7.
And I have received anything else about them, when you receive the police report, and no further. And, yeah, and no, the white person, first time talking, is October.
Mr. Dewey, you're here on New Traditions?
Correct, and SMS acquisitions.
All right. That was set for 10 o'clock. I can probably, let's go ahead and call that case, Mr. Dewey.
We had a 10 and 10:15 on the two of them.
All right. And that's with J.C. Lolar
Yes.
and Galen Burris.
Correct.
All right. So we're on the record in docket 23-00749. That's New Traditions Lansing versus J.C. Lollard and Galen Burris. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Good morning. Sam Dewey here on behalf of plaintiff.
Okay, this is positionally set for pretrial in the matter. This is a second pretrial. The first one, defendant failed to appear. We set it, we had service by attachment. We set it for second hearing on today's date. I do not see a J.C. Lolar or a Galen Burris in the Zoom courtroom. There's nobody in the waiting room and nobody that answers to that name in the physical courtroom. Is there a J.C. Lolar or Galen Burris in the physical courtroom? Without any answer, it appears that the defendant has, defendants, both of them, defendant 1 and 2, have failed to appear for the second hearing once again. Oh. Right. So this time, Ms. Williams, I'm gonna have you keep it down so we can just, and I think one of you is talking in the microphone. So, all right, so we have a second FTA for the second hearing. Mr. Dua, how would you like to proceed today?
Thank you, Your Honor. Plaintiff should move for a default possessory judgment to enter and request that the monetary judgment be severed and adjourned based on lack of personal service. To the best of my knowledge, this is a residential unit fit for that use, and neither of the defendants are either minor, incompetent, or in the military service. I have a judgment prepared, if I may approach.
You may.
Thank you.
In order to that effect. Thank you. So this is in regards to possession only and then severing the money judgment.
Correct, Chair.
With that understanding, I will sign the document today's date. Where they failed to appearance a second time at the second hearing. Anything else for the record in docket 23-00749, Mr. Dua?
Nothing, Your Honor. Thank you.
All right, thank you, Mr. Dua. And then I think we can call your second case now too.
That would be great.
Yeah. 752. All right, and we're on the record in docket 23-00752. That's S&S Acquisitions versus Joseph Smith and Joyce Smith. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Sam Dewey here on behalf of the plaintiff.
This is the time set for a second hearing. This was initially set for May 3rd. The defendant 1 and 2 failed to appear. We had service by attachment. This is scheduled for 10:15. It is now 10:34. It would appear that defendant 1 and 2 have failed to appear for the second hearing. Mr. Dua, how would you like to proceed?
Thank you. Your Honor, this action stems for a complaint for possession after mortgage foreclosure. The redemption period has since expired. Plaintiffs should move for default possessory judgment to enter with a last day to vacate of May 25th, 2023. And I do have a judgment prepared, if I may approach.
You may.
Thank you.
Thank you. All right, so this is possession only on a this is a Want to find the original complaint. So it's filed with landlord tenant, but it's
The original complaint, Your Honor, was filed under 600-3237, 3238 for defendants not allowing a plaintiff, third-party successful bidder to inspect the premises. However, due to the court's schedule, the redemption period has also since expired.
okay. All right, so I will sign the order in regarding to possession only and the May 25th date. Last day to vacate, May 25th, 2023, which both dates are signed on the order. Anything else for the record in docket 23-00752, Mr. Dua?
Nothing further, Your Honor.
All right, you should be all set. Thank you, sir.
Thank you.
I think that's, oh, you're with us this afternoon, aren't you?
I am.
Okay.
Yes.
We'll see him in a little
Yeah,
bit.
we'll see you. We'll see it too.
Our internet has been down at our office since late Wednesday night. And so I was like, everything now is like, all of our printing is wireless.
Right.
Our phones are connected. We have no phones. Nothing. I was like, I'm going in person.
Right. It's just like the old days.
That's right.
Right. Well, I think we take that convenience for granted on some level. Ms. Reed, we'll call your case now. We're on the record in docket 23-01129. That's the City of Lansing versus Markisha Reed. Will the parties please introduce themselves for the record?
Assistant City Attorney Emmanuel Williams appearing on behalf of the City of Lansing.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter appearing today on behalf of Ms. Reed, who joins us via Zoom.
Ma'am, you are Markisha Reed?
Yes, sir.
And you can hear me all right, Ms. Reed?
Yes, I can.
All right, this is the time set for a pretrial in the matter. Ms. Williams, how are we proceeding?
Your Honor, would like to request an adjournment for 60 days for compliance purposes.
So this puts us out till July, right? 74 days. Can we do 30 days to start and then reevaluate after 30 days?
My concern with that, Your Honor, is we've done that in the past and we come back in 30 days and the court has
It's
the
not
concern.
done.
Yeah, and then we're running to the issue. Well, we've adjourned once, even though we tried to adjourn for longer.
But
And
it's just that that puts us out at 70 days, which is, it's not it's just, it's a lot for furnishing false information.
Right. And I suppose some of the reasoning might help the court. She's been asked to complete some community service hours and she's a single
Okay.
mom working 2 jobs.
All right.
So it's going to take her a little bit of time to do that.
All right, so it really is for kind of a compliance pre-diversion type of thing.
Yes.
All right, so we'll set this for 60 days for the July date of. July 17th at 9 a.m. So, Ms. Reed, please keep in contact with your attorney, Lauren Sutter. We've reset this for July 17th at 9 a.m. Okay, ma'am?
Okay, thank you.
All right. Anything else for the record? Docket 23-01129. Ms. Williams.
Hi, Your Honor, thank
Ms. Sutter?
you.
No, Your Honor, thank you.
Okay, you're all set. You're all set,
Thank
Ms.
you.
Reed. Thank you for your appearance today.
Thank you. Thank you. Have a good day.
You too. And then if you can give Mr. Embry that order.
I did.
Okay, so he's all set. Are you all set today, Ms. Sutter?
For you, Your Honor, I
For
am.
me?
I'll be with Magistrate Milmore the rest of the day.
All right, we've got one pretrial at, that's a landlord tenant.
Oh, that's all for
We're all
you then.
set. You're all done with me.
Yay. And I think Ms. Robinson's coming back for a probation violation separate.
All right,
What about
who's that?
The other page.
I set that aside. And nobody appeared on it.
Oh, thanks.
There was a show cause. You said show cause for May 15th. He obviously didn't have it on his file. It doesn't look like anybody was served. What if they? Let's contact Mr. Smith and see what he wants to do on this, because I don't have service, so.
Well, the civil department, after I scheduled it for today, scheduled it for 6:26.
All right, that works for me.
So I don't know.
I'm just gonna put on today's date, scheduled for June 26th. June 26th, 2023, for civil, right?
Yeah. I don't like the 60 days.
Yeah. I got that.
You get it?
So we're on the record in docket 21L26544413. That is City of Lansing versus Maria Barrera. This is the time set for a show cause on 192 balance. It would appear that the defendant has failed to appear today for the show cause hearing, and the court will issue a bench warrant and bond forfeiture. We are also on the record in docket 21L2612712791. That's City of Lansing versus Spencer Correa. This time set for show cause hearing in the amount of $258 in outstanding payment to the City of Lansing. I do not see, this was set for 11 o'clock. It is now 11:20. I do not see Mr. Correa in the Zoom courtroom or the physical courtroom. And so Mr. Correa has failed to appear for his show cause. And I will set a bench warrant and bond forfeiture. And that's all for the record in docket 21L26122791. And then we have docket 20L25536661. This is, looks like a show cause hearing that was set on a balance of $197. It was set for show cause at 11 o'clock. It is now 11:21. Appear that Mr. Friesman has failed to appear for show cause, and a bench warrant and bond forfeiture is set. And that's a balance of $197. That's all for the record in docket 2020 L255361. For the record, there's nobody in the Zoom courtroom or in the physical courtroom, so Mr. Friesman has failed to appear. And then we're on the record in docket 22 L27000062. That's City of Lansing versus Michael Jackson. This was scheduled for 11 o'clock. It is now 11:21. It would appear that Mr. Jackson failed to appear. Check the Zoom courtroom or the physical courtroom. This is on an outstanding balance of $258. Defendants failed to appear for the show cause, and a bench warrant and bond forfeiture is issued. That is all for the record 22 L27000062.
It is.
What's that?
That's a judge court case. How we ended up with that.
Mr. Hernandez, are you represented by counsel today?
Because that's supposed to be the person.
Say it again. Mr. Hernandez, are you represented by counsel today?
No, Your Honor.
Okay. All right, so we're on the record in docket 20-02952. That is City of Lansing versus John Hernandez. And sir, you are John Hernandez?
Yes.
All right, and Ms. Williams, your appearance for the record?
Good afternoon, Your Honor. I'm Manny Williams, Assistant City Attorney, appearing on behalf of the City of Lansing.
All right, Mr. Hernandez, you've indicated you are not represented by counsel today, is that correct?
Yes.
All right, Ms. Williams, are we going to hearing on this, or what information do you have on this?
I don't have any information. I don't even have the case file. I'm here.
Right.
Probation violation.
All right.
It seems that this is an older case.
It
and
is.
We don't usually keep case files.
What is your intent to do today, Mr. Hernandez?
I'm not sure. Brent, when I talked to my probation officer, Brendan, he told me that I needed to make a payment in order for him to process my my discharge, and I did so. Correct. And he said that I would be discharged before today. That way, this gets off. It'll just get thrown out. Is what he told me.
Right. I kind of have the same thing. I have that as long as you made a payment before this date, today's date being May 15th, and it appears that you made a payment on May 11th. Is that correct?
Yeah.
And on May 11th, and what was the amount of that payment?
200, I believe.
Okay. And you owe 74.29?
No, my balance should only be $400.
400?
Yeah.
Or for a I think we have you at less than 100.
Oh, I see. He's got multiple counts. So he owes $399.
All right. So we'll send it. So as far as your probation's gone, since you made that payment, and that was the indication I had, you were told that if you made a payment before this date, you would be satisfactorily discharged. I'm going to discharge you from probation on this file. So that's file. So that makes sense then. And so on file 20-02952, I'm going to discharge satisfactorily, with satisfaction from probation, and then I will refer the rest that you owe on everything to collections. All right.
Okay.
Yeah. So any further amount referred to collections, which you still have a collections case out there because you've got other money on this file that we're just going to refer to collections. Does that sound right?
And how much is that?
I did. It's like $399.
I was only aware of the. Yeah. Yep. Okay. Yeah.
Yeah. But that's on everything together.
Okay.
Okay. So refer remainder to collections.
And would I still be able to make the payments online as I've been doing?
Yeah, I don't know. See that I don't know. I think you have to come in and go to collections and set up a plan with the collections here, and then they can set it up however you want. but then that's done, that's a separate process to the criminal process.
Okay.
So so refer to Marquita on the 6th floor, right? So you should come to the 6th floor and see Marquita. What's her last name? Markisha Taylor on the 6th floor, and she'll set you, and then you can talk about setting up a plan for the remainder of the money. But your probation, you're discharged satisfactorily.
Okay.
Okay. All right. So I've
Sounds
indicated
good.
that discharge satisfaction on probation. The remainder amount is referred to collections, and you should be all set, Mr. Hernandez. Okay.
Okay, thank you, Your Honor.
Thank you. That's all for the record in docket 20-02952. You don't have that in. You don't have anything in there.
Issue with the probation department, the paralegal, the office reached out,
Okay.
tried to getting we need the case files, because I need to review the case
Okay.
file, and they refused.
Okay.
They did not want to release any case file.
So you're all set, Mr. Hernandez. Thank you for your appearance today. Mr. Carter, what case do you have today?
Skeen. Glenn Skeen, two of them.
We have that for tomorrow.
Really?
So,
I have it for
yeah.
today.
Yeah,
Let's see.
I might have misspoke, but it's not on my, it is set for tomorrow and it's not on my docket today.
At what time?
1:30.
At 1:30 tomorrow afternoon.
Okay. Awesome. Thank you.
All right, I'll see you tomorrow
I felt
afternoon.
bad that I was late. I had it scheduled at 1:30 today.
Well, you covered all your bases.
All right. Thank you. God was looking out for me.
All right.
Hey, thanks for making me not sit there forever to figure out why I was there.
You're welcome.
Bye.
Miss Rower, you're here on a probation violation arraignment. Do you understand that, ma'am? Yes. All right. So I'm going to call to the record docket 2201692. That's people of the state of Michigan versus Madison Maori. And I'm going to read you the nature of the allegations of the probation violations brought against you, and then tell you some of the rights you have to have this hearing on this. All right. This is on a request and summons for probation violation. It was signed by Jody Bayless on May 2nd, 2023. It was co-signed by the court on that same date. There's an indication that you failed to refrain from alcohol per AberHealth on April 20th, 2023. You tested positive for alcohol, and that it indicates the positive results. So that is the nature of the violation, is the testing positive for alcohol. Do you understand the nature of the allegation brought against you for violation of probation?
Yes, Your Honor.
All right, and you know you have a right to hearing in this matter, and so you have the right to counsel, you have the right to hearing. We usually schedule it about a week to 14 days out so that you can, I see under the underlying charge that you were represented by the public defender's office. You can be represented by them again today, but you're gonna have to seek their representation. It's not the same where they show up at arraignment and then you're assigned it. Is that what you want to do today? Do you want to seek representation from the public defender's office? It's probably a good idea.
Yes.
All right. All right. So that's upside down, but so let's get you the number to the and I want to make sure that you've got the right number. Do you have that? So what you're gonna have to do is we're gonna set it for hearing. You're gonna give them, and you'll call them, and you're gonna tell them you want to be represented at hearing, and then give them the date, and then they'll be able to contact the probation officer. It's probably the most important thing you can do. So give it high priority, because right now there's an indication. It doesn't mean that you're going to jail, but you could face jail time, and so you want to make sure you're represented. All right. So Mr. Neves is taking her back. So I'm going to have you, we're going to set it. So it's set for.
We have to go out because of Memorial Day.
Okay.
So let's do June 5th at 1:30.
All right, we'll set the hearing on June 5th. We have to go out a little bit. At 1:30?
Yes.
Well, at 1:30, we're going to set the hearing. And what I'm going to do is go ahead and come up here. This is the information to contact the public defender's office. So make sure you contact them in the next couple of days. Tell them that June 5th date has been set and that you're seeking representation, okay? All right. Any questions of me, ma'am?
No, Your Honor.
You're all set.
Thank you.
Thank you.
Ma'am, if you could just wait one moment, I'll get you a notice to appear. Okay.
Yeah, we'll print it off and we can grab it for you.
Still calling them for a second. There you go. Thank you.
All right, you're all set, ma'am.
Thank you.
Well, I know that Daniel's taking it.
Oh.
Mr. Doric, how are you?
Very good, thank you.
They sent somebody back after Judge Ward's office, I think it was absent, so I was trying to get that figured out too.
Mr. Dewey, we can start calling your cases when you're ready, if you're, depending on who's here.
I only have plaintiff's agents here that I
Okay.
know of.
All right, Mr. Doric, is Miss Ashley Love here? All right. Are you ready to go on the record on that case? Go on, come on. All right, we're on the record in docket 23-00556. That is Todd Doric versus Ashley Love. Will the parties please introduce themselves for the record? All right, and ma'am, you are Ashley Love?
Yes, sir.
All right. This is the time set for a formal hearing in the matter. It appears we're here on March 8th. All the parties appeared. That there was some indication of meeting with legal services. We set it for this date. Mr. Doric, how are we proceeding today?
We would like to proceed with the consent judgment.
So you have a consent judgment.
Yes,
Did you want to place any terms on the record?
yes.
Go ahead.
For the possession amount, the rent owed is $2,655. Court fees were $142.16 for a total of $2,797.16. The money judgment through today's date is $2,035.64. The court costs are $142.16 for a total of $2,177.80.
And do you have a vacate date or anything along those lines?
I guess I need help with that, with whatever date you're using for that.
Yeah, so it'll be, if I plan to sign the consent judgment today, it'd be 10 days for the date from today's date.
Okay.
I don't know if that's enough time for Miss Love to vacate the premises in that fashion.
Not really, because I thought we was working with the housing, the capital area housing program.
All right, so is this a pay or vacate?
This is a pay or vacate. However, I've been working with Ashley to get help from Capital Area Housing Partnership. The judgment will help her get that.
Okay.
So although the writ date would still be then 5/25/23, I certainly hope not to have to actually evict her.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10. So I can, so that date right now would be 10 days from today's date. I'd sign the date today. But my understanding is Mr. Dowrick's working with you for
Yes, sir.
assistance. And so the plan is to see if you can get payment by that date. You'll need the order for that to see that. So I'll set the vacate date at, well, it'll be on the order as May 25th. So the numbers that Mr. Dowrick talked about, those are all how you understand the numbers?
Yes, sir.
All right. And right now, you're going to get an order to that consent judgment effect that'll indicate that May 25th is the writ date. You can, with order in hand, go and see if you can get some rental assistance and then work with Mr. Dowrick, okay?
Okay, yeah, that's what we're in the process of doing now.
All right. All right. Is that my understanding, Mr. Dowrick?
Yes, sir.
All right. Did you have an order for me to sign, or did you want to just submit the order?
If I had the form, I could complete it now.
Yeah, but if we can print them out, I don't know if we can print out a consent judgment. Yeah, I think you'll have to go to the civil department and get a consent judgment form.
Okay. All right.
But with that understanding, once I sign it, If I sign it tomorrow, it'll be the 26th. If I sign it today, it'll be the 25th. All right, ma'am? Anything else for the record in docket 23-00556, Mr. Dowrick?
No, sir. I'll go downstairs and try to get a
All right.
judgment form and then bring it back.
All right. If you can bring it, or if you submit it, it'll come to me this afternoon.
Okay. Sounds good. Thank you.
All right. Any questions, Ms. Love?
No, sir.
All right, thank you. You're all set.
Thank you.
Yeah.
Francisco Blake, one that was supposed to go over this in person.
Okay.
He was, but apparently he had a case with Judge Ward too. So after he was done with Judge Ward, they sent him back to ICJ without seeing us. So they can't put him on Polycom until after 3:30.
All right, that's Mr. Dua's. So Mr. Dua, just, you know, Mr. White, on your first 2 o'clock case, he can't be put on, he's incarcerated.
Right, we found that out last week.
Yeah, so they can't put him on Polycom till after 2:30?
After 3:30. They brought him over in person, but he had a court date with Judge Ward, and after his court date with Judge Ward, they sent him back over there without.
Oh, they
being
didn't
sent.
realize he had another one.
Right, right.
But we will be able to hear that one today, yes?
Yeah, I think so.
And It'd have to be after 3:30.
3:30?
Yeah, unless you want to just reset it.
I'd prefer not to.
Okay,
This was filed in December,
okay.
so.
Yeah, we're not going, it will be here.
Yeah,
so.
I have a 2:30 54B by Zoom. I'll just do that here
All right,
in one of the conference rooms.
okay.
And then.
And then
I'll
when
step back and-
we pull them up,
Yeah.
yeah.
I'll call you if I need you. Oh, that's fine.
Yeah, he's,
After 3:30, I'll call you if I need you. Yeah, Your Honor, would it be permissible if my client needs to testify, could he do it by Zoom?
yes,
Since we have this,
yes,
I anticipate that at best there'll be one exhibit.
okay, so, yeah, I mean, since we don't have him here, and since, I mean, you don't want to wait an hour and a half, so.
All right, sure.
All
You
right.
want me to reset it? For 3-4 weeks from now? Right in front of the judge.
I'm gonna take that as a no. I'm gonna take that as a no.
I'm not
Okay.
gonna say the metal detectors downstairs. In front of
All
the
right.
judge and
So
everything.
we'll see you at 3:30.
Yeah, take care. Yeah. Now you lock me in. Ow.
All right, Mr. How about Miss? We still have time. Those are 2 o'clock cases.
Yeah.
Okay. So yeah, we can do. We just gotta wait for Mr. White, huh?
Trouble you for another judgment. Last one, we just got our internet and printing capability back while I was sitting here. We go this one, because I have one for White. So let's spin from last time,
Gomez.
please. Yes.
Because you're such a good client, Mr. Bill.
I'm sorry?
Because you're such a good repeat customer.
Oh, yes. You guys don't have a rewards program for the fire.
No, we don't. You don't get.
Oh.
You don't get
we
a
really
discount,
should.
right?
Yeah, we really should, right. I've been saving you guys a lot of stamps. Every time I walk down to the 5th floor, Stephanie gives me them. She's like, here, we don't have to mail these.
Right.
Here you go.
And then Mr. Klug, you're here on your 215.
Yes,
Okay.
correct. I don't, I'm not sure what she looks like. I don't know.
I'm not sure either. That's Al Shalal.
Yeah.
Al Shalal. And so are you, Mr. Dewey, you're waiting on Miss Gomez?
I'm right here.
Okay.
Oh,
I'm Vanessa
All
Maori.
right. So did you want to speak to her a little
yes,
bit? Or?
please.
Okay.
I didn't know that was it.
Yeah. I'm just a little chat.
Okay. You can do an overrun around the 2:30. Mr. Kozer, how are you?
Good. How are you today, Judge?
I'm good. What case did you have today?
I actually didn't have a case today. I was logging in. It was South Washington Park versus Al Shalal. She had contacted our office late and wanted me to at least hop on because part of her story was she was having some issues with a phone getting stolen.
Does she plan on, I have the moving party, South Washington Park, along with the attorney here. Did she plan on joining us?
That was my understanding.
All right, all right. So we'll give her the allotted time to see what's going on with the case, but she's not here yet, I guess.
All right, thank you.
All right, thank you. Back on the record docket 23-00556. And this is the order. I'm just indicating I'm signing for the order, the consent judgment. You've also signed the answer and consent, ma'am. Is that correct? All right. All right, so that's signed, and you can get a copy of from Mr. Neves, all right?
Okay.
All right, thank you.
stand up there?
Yeah, you can, and you can have your, and Mr. Cozart, are you there?
Oh, you're standing.
All right, so let's go ahead. Miss Shalal is here.
It's El Shalal.
Al Shalal?
Yes,
All right.
sorry.
No. And we're on the record in docket 22-04222. That's South Washington Park versus Sharifa Al Shalal. Will the parties please introduce themselves for the record?
Good afternoon, Your Honor. Jeff Klug, appearing on behalf of plaintiff, South Washington Park.
And ma'am, you are Sharifa Al Shalal?
Perfect. Yes.
Okay. And Mr. Cozart, is your agency representing Miss Al Shalal on today's date?
No, Your Honor.
Okay. So you do not intend on filing an appearance on this case?
No, Your Honor.
All right.
Wait, I have your retainer.
Correct, and we did not receive that retainer back, and we hadn't made contact with you until I believe it was Friday. And that's what we spoke about on the phone.
Yeah, and you said that you would appear on my behalf to ask for an adjournment so that you would have more time to refer to my case.
That's
Right?
not exactly what we discussed.
It's not?
No,
No,
it's not.
I recorded, I know.
No,
That's
I agreed to show up today to help explain what had happened with your phone today. And if you requested an adjournment, I would be able to corroborate that part of our interaction, but I did not say I would be entering an appearance.
Oh, no, oh, I'm sorry, I'm confused. No, I know you weren't gonna enter appearance. I'm
Okay.
sorry. I misunderstood. I have a brain injury, so I'm so sorry, yes. Because it had already been adjourned once and I didn't want it to seem like I was just trying to procrastinate.
Right.
And you do have that information. I'm so sorry. That was my fault.
So
I'm really
Mr.
sorry.
Klug, we are set for hearing today.
Yes.
Would you like some time to speak with Ms. Shalal to see if you can resolve this, or we're going to go to hearing?
Correct, Your Honor. Yes, I'd welcome the.
All right, so Ms. Shalal, so Mr. Kozart's not filing an appearance. He's only here to explain why that you're at least explain why you're asking for an adjournment. This is set for hearing today. Mr. Klug here is from the opposing party. Hearing's like a bench trial. Okay, so you bring your evidence and I consider the evidence, all right?
Yeah.
I think maybe you should talk to Mr. Klug to see if maybe this is resolvable.
Definitely.
All
And,
right.
Also, they did take my case, legal aid, but when I contacted them, they said that they didn't have time.
It appears that they did not take your case.
No, they did. I have the retainer.
She is
know
correct,
what
Your
a
Honor. The case was accepted, but because of a delay in contact, it did not leave enough time to actually prepare for the case.
All right, so let's let you talk to Mr. Klug, see if you can work this out. If not, we'll put it on the record, okay?
Okay.
All right.
Yeah.
All right.
I'm not really prepared and I don't have enough advice, but.
Well,
Hey, I
you
just-
should meet with the opposing
Oh,
party
yeah,
at
I'm
least.
sure we
Yeah.
can work it out anyways,
Okay.
the two of us.
All right, so at this time, let's have you meet with the opposing party and then we'll come back and put if anything happens on the record, all right?
Okay, all right. Thank you, Judge.
Thank
I
you.
appreciate it. Yeah, if you wanted to maybe tell them what happened with my phone, that it was stolen.
All right, so, and Mr. Klug, feel free to take your property manager and.
Yes.
Okay,
All right, thank you, Judge.
thank you.
But do I have to download the Zoom thing you do? Yeah. I still gotta do that part, huh? Huh? Yeah. Well, I need to hang up. Hang up.
Your Honor,
Mr. Kozer, go ahead.
Oh, I was gonna say, I don't know if Wendy is sitting just off screen of what I can see or not.
She is.
Yeah, we were able to do an intake with Miss Adams and we will be accepting that case.
Oh, great. Thank you so much for doing
right.
that.
And then depending on what happens with Miss Shalal, we've got a date that we're looking at a date in that regard too. But let's see if that case is, well, let's see what happens.
See what happens before we jump on that one.
Right, exactly.
Hello? Can you hear me?
We can, ma'am. Are you Vanessa Jeffries?
Yes, sir.
All right, and you're here for your 245?
Yes, sir.
All right, stand by.
Thank you. I apologize.
We were kind of tiptoeing
Miss
out.
Jeffries,
Yes.
we're gonna call your case.
Okay, thank you.
All right, it's 4238. You are not represented by counsel today, is that correct?
No, sir. I was
And
the thing.
now, is there a reason why you're not live in person today for this hearing?
Oh, I didn't know I was supposed to be.
Well, it says live in-person hearing on my notes, and the
Well-
plaintiff's here live and the lawyer's here live. So I'm wondering why you're not here live.
Because the paperwork that I got just told me to do it again through Zoom.
But what did I tell you at the last pretrial?
Sir, I apologize. I thought I was supposed to come this way. What can I do? Because I do apologize. I didn't want to not miss the meeting.
Well, I don't want to adjourn this matter. So, and where do you live, ma'am?
I stay on Newark Street on the south side of Lansing.
Your Honor, she'll likely enter a conditional or
Conditional dismissal?
a consent dismissal.
All right, so it's not going to be a contested hearing. Okay, then we're good. Okay, I think so. As long, so I'm going to call to the record and we'll work this out. All right, Ms. Jeffries?
Please do. Yes, sir.
All right. We're on the record docket 2204238. That is Sophia Emineth versus Vanessa Jeffries. Will the parties please introduce themselves for the record?
Good afternoon, Your Honor. Victoria Osborne for the plaintiff.
And ma'am, are you Sophia Emineth?
Yes, I am.
All right, thank you. And ma'am, you are Vanessa Jeffries?
Yes, sir.
All right. So the time set for a formal hearing on this matter, and it's my understanding, have you had the well, Ms. Osborne, how are we proceeding?
Thank you, Your Honor. I had the opportunity to speak with Ms. Jeffries at the pretrial conference. She did not deny owing any rent. That was quite some time ago.
That would have been March 15th?
Yeah, in this case, yes, Your Honor. And this case was filed in December. So at this point, Ms. Jeffries owes $5,700 to retain possession with court costs in the amount of $241.56. That's a total of $5,736.56. And I prepared a judgment if she's willing to consent to that.
So Ms. Jeffries, the indication from Ms. Osborne and the moving party is that you owe back rent in the amount and with court costs of $5,736.56. Do you have any dispute to owing that amount of past rent in this matter?
I don't at this moment. And then I just want it to be known that I am going through DHS regarding help with my rent. I did submit a SCR. They have up to 10 days. They haven't gotten back in contact with me. I did communicate with them this morning. However, they was telling me how the courts are, they work with the courts, and the guy name is Jay Guyton told me to let you all know that indeed they're working on my SCR immediately. And I've called other resources.
So, but you're not indicating that you don't pay you don't owe the rent, so there's no
No,
matter of
I'm-
dispute.
I don't dispute that. I do owe the rent. I do owe the rent.
All right, so
I don't-
so there's no legal issue for me to decide. Ms. Jeffries, is it my understanding that the place that you rent is habitable for its intended purpose?
Yes, sir.
All right. And it's my understanding you're not a minor, you're not incapacitated, and you're not serving in the military.
No,
Is that
sir.
correct?
I'm just disabled.
All right, so I don't have any legal dispute except for a vacate date at this point.
And
Okay,
Your Honor,
this-
I spoke with Ms. Jeffries during the pre-trial conference, and she was speaking with DHS at that point in time. So I'm just gonna request the 10 days.
Okay.
Pursuant to
So
statute.
Ms. Jeffries, I don't see anything in dispute other than you can't pay. It's not that you won't pay, it's just that you can't pay.
I don't have the money to pay, and I'm trying to get the assistance to help pay with what I
Alright.
do have in hand. I just don't have enough in hand to pay. So I was trying
Well,
to
you're
get
look-
assistance from,
If I sign the order today, it would be a vacate date of May 25th.
I wouldn't be able to leave in the 25th, sir. I'm just asking if you all could just hold on for me for a little bit longer so I can
we
vacate. I
can't.
will be willing to vacate the premises.
Well, the writ, you can seek a writ in 10 days. So you can decide when a good date is for her to leave after 10 days. What it does is you can seek a writ, you have what, up to 90 days to seek a writ after that 10-day period.
Yes, Your Honor.
But it's incumbent upon you that if you want her out by the 25th, you can, but you can seek a writ for that day. Ms. Jeffries, I don't see an issue here really, except that you don't want the sheriff at your door moving your stuff out for you, right?
I do not, sir. I do
All right.
not. And
Well, right now, the date would be issued on May 25th.
can I ask Miss Pat and Miss Sophia if they at least get me to the 1st so I can get everything going, even if I gotta put my stuff in storage or in someone's basement?
Well,
But-
that's between you and her. That if she wants to give you some grace in relation to allowing you that, that's between you and her. But my date's gonna read May 25th today. I don't even think you can put it in the form of a consent judgment, but I don't think it's a legal issue, really.
It's not, Your Honor, and I offered a consent judgment at the time of the pre-trial conference so that she wouldn't have a judgment on her record if she wanted to vacate on a mutually agreed upon date.
Right.
But
Right, and I
not-
tried to get help through legal services and no one never
Right.
got back in contact with me.
Well,
And I
ma'am,
kept
I
housing-
mean, we're in a position now where it's just too late. I mean, in regards to legal services, you know, there's no legal issue here. The issue is not that you can't pay. It's not that you don't owe. It's just that you can't pay. And at some point in time, that meter runs out. So if you have an order,
I do, Your Honor. I did not know if Ms. Jeffries would be here today, so it's not marked as far as
All right.
default or consent.
so I don't see it's not a default, and I don't see it as a consent judgment. I don't see she's contested any of the, so I'm going to indicate by hearing, because she's pretty much indicated exactly what she owes. It's not any type of, it's not any type of legal. All right, so I'm going to sign the judgment of landlord. I don't see it as a legal issue. I find Ms. Jeffries has indicated that she owes the money. I have a May 25th date on vacate. I'll indicate the date for appeal is also May 25th. And so it'll be May 25th is your vacate date at this time, ma'am. If you talk to the property manager or whomever, and they give you some grace in allowing you to be further, that's between you and them. But the May 25th date is the date that I'm using today, okay?
Yes, sir. Well, Miss
All
Pat
right.
and Miss Sophia, are you and I able to communicate?
You're more than welcome to contact me, Ms. Jeffries.
I'm sorry.
You're more than welcome to contact me. My contact information is on all of the legal documents.
Okay, because I don't have any of that paperwork. I didn't get no paperwork from the last time you and I spoke through the Zoom. So can I have your number, please?
Sure.
She can put it for the record for a place to contact her.
Yep. So my office number is 517
517 482
0222.
Thank you kindly. Am I able to call you shortly?
Sure.
I thank you and I truly apologize.
So let me, I'm signing this. I'm sending the landlord tenant order. I wrote that there's really no legal issue, that there was an admission of the amount owed. And then I find, based on that and the representations made to the court about the amount owed, I find by preponderance of the evidence that you've proven your case. So we'll treat it as a hearing regardless. And I've signed your consent judgment. Anything else for the record in docket 2204238, Ms. Osborne?
No, Your Honor.
All right, Ms. Jeffries,
Yes.
you're all set today. That May 25th date is the main date you should look at. If there's some grace period that they allow you, that's fine, but you should look at that May 25th date, okay?
I thank you so much, Your Honor.
All right, you're all set. Thank you, ma'am. You're all
Have
set,
a
Ms.
great day.
Osborne.
Judge Flores, Tom Siver. I'll be dismissing both of my cases with you today.
I'm trying to leave the lead.
All right, Mr. Siver, let's call your, and I heard what you said. So
Thank you.
We're on the record in docket 2204225. That's Calderon LLC versus Calderon LLC and DS Huber Real Estate versus Brandon Dunn. Will the parties please introduce themselves for the record, Mr. Siver?
Tom Siver on behalf of the plaintiff.
And it's my understanding that your representation to the court is that you're moving to dismiss
Yes, Your Honor.
this case. Okay, move to dismiss at plaintiff's request. All right, so your motion to dismiss is granted.
Thank you.
All right, and you should be all set on docket 2204225. And then I have you on docket 2204228. That's Tilgard LLC and DS Huber Real Estate versus Johan Johnson and Tori Johnson.
Yes, Judge, we're moving to dismiss.
And your appearance for the record?
Tom Siver on behalf of the plaintiff.
All right, it's my understanding on this case also you plan to move to dismiss, is that correct?
It is, Judge.
Dismiss. Granted. So on both those files, you'll be following up with an order to dismiss on 4225 and 4228?
Yes, Judge.
All right.
Thank you.
Thank you, Mr. Siver. You're all set.
Have a good week.
You too.
This is the wrong file, Judge.
Which one is that?
Wait, this is the one we're waiting to do this afternoon. You dismissed.
Which, let me see. That's Francisco White. I need 4228.
Yes.
Thanks.
I'm here to help.
And this is plaintiff moves to dismiss. Order to follow. Move that one. Sir, do you have a case today?
Yes, sir.
What's your name?
Ray Wong.
Oh, you're the landlord in Springer, Sparks and Sorrow.
Yes, sir.
All right. So I'll call your case in about 7 minutes.
Okay.
Yeah. All right. Hmm? We're on the record in docket 22-04404. That's a Monopoly Apartments LL versus Sam Johnson Bay. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Sam Dua here on behalf of the plaintiff.
All right, this is the time set for a motion to set aside the possession of judgment, and it was filed on May 5th by Mr. Johnson Bay, and his indication was that his residence had a bed bug problem, and he attached information. Now, I gotta say for the record that I'm wary of this initially, but it came to me, and he had money to put in escrow. So he put the money into escrow. There's $300 in escrow. But as I went through his paperwork, all of his paperwork is from being treated for this is from 2022, November of 2022, May of 2022. And then we have something from the Great Lake Clinics that would indicate out of 2000. So that didn't make any sense. And the nature of the order kind of makes sense and kind of doesn't. But I granted it based on the 1 month rent that was deposited. We're now set for formal hearing today. It was set for certificate of mailing was sent out. Notice of hearing was set on the May 15th date in front of myself. And it appears that Mr. Sam Johnson Bay has failed to appear, and he previously failed to appear on March 22nd. And that's why we had the default judgment. So I think every opportunity's been given for this individual, at least from my perspective. And so this was scheduled for 2:30. It is now 3:04. It would appear that the defendants failed to appear for the motion to set aside eviction. And so I'm gonna deny I'm assuming you object to the motion.
Correct, Your Honor.
So I'm gonna deny the motion to set aside, not only for argument for default purposes, because he's not here. I'm gonna indicate that the plaintiff is entitled to the escrow payment to plaintiff for appearance in the matter. So the motion to set aside is denied. And the eviction to continue. All right. So we once again have a fail to appear at the motion to set aside. Anything else for the record in docket 22-04404, Mr. Dua?
Just a question, Your Honor. Was an order of eviction filed by plaintiff in that case?
It never got that far.
I see.
Yeah.
Okay.
I think we called you to inform you of the stay on May 5th.
Okay.
There's indication, but it was late. It was late, but it never got to the eviction. Yeah.
Thank you.
To that.
Nothing
So,
further.
all right. Thank you. That's all for the record. 22-04404. I can call Mr. Walling's case. So Mr. Walling, you can just come on up and you can have a seat right there. So we're on the record in docket 23-00523. That is Randy Walling versus Juanetta Springer, Christopher Sparks, and Diana Sorrow. Will the parties please introduce themselves for the record?
Randy Walling.
Okay, Mr. Walling, you're here for the plaintiff in this proceeding. This is a terminancy of tenancy hearing. It was scheduled for 2:45. It is now 3:06. It would appear that defendant 1, Springer, defendant 2, Sparks, and defendant 3, Sorrow, are all failed to appear for hearing. And I'm assuming, Mr. Walling, at this point in time, you'd want a default judgment.
Yes, sir.
I will indicate for the record, we previously met on February 15th, 2020. All parties appeared. They were told to be here live in person for a live hearing. So the default's granted orally. What you're gonna have to do is submit an order to me to sign it, and that's when that's when everything will take place. You have it with you. All right. So if you approach, I'll take a look at the order. Thank you.
Thank you.
So default judgment in the amount of right to recover and past payment. And then there was a money judgment. Damages. All right, I'll sign. Is possession still an issue in this case?
I don't believe so.
But
Drove
just
by there today and it's looking pretty empty, although
Okay.
the keys have not been returned.
All right. Sir, do you have a case today? What's your name?
Sam Johnson Baker.
Okay, that's the case. We just called your case, but we'll go back on the record on that, okay?
So much say.
All right, so Mr. Walling, I've signed the order. You can get a copy from Mr. Neves. You should be all set, okay? Thank you.
Appreciate it.
All right, Mr. Dua, this is the case. So the last case, all right. All right, Mr. Johnson Bay, if you come on up. We had just denied your motion. Right.
Well, you know, that's what they
So
stole.
you can have a seat right there.
They stole my truck.
All right. All right, so we're back on the record, docket 22-04404. Mr. Johnson Bay has appeared, and so we had you fail to appear as you were 30 minutes late. So Mr. Johnson, this is your motion to set aside the order. I guess you were failed to appear on March 22nd, 2023. And that's when the default judgment was granted on the March 22nd date. So what is the basis for your objection?
All right. I've been there for 7 years, sir.
So why weren't you here on March 22nd?
Well, I didn't see no ground for them to have me in court. My truck been stolen.
Really not much of that's not an excuse for not coming to court. The fact that you thought you couldn't be in court doesn't mean anything.
I hadn't done that.
But Mr. You understood you needed to be in court on March 22nd.
I understand all that.
So you chose not to come to court. And then what happens when you don't come to court is there's a default judgment.
They had sent me those about 4 different times. Meanwhile, I've been fighting big bulls, bakeries, being stalked.
Okay, that doesn't change the fact that you're supposed to be here on March 22nd, and that was the order. Okay, so that's what we're fighting here. I've given you the opportunity to set aside this eviction because you're coming here to explain to me why. And what you've told me is I didn't want to come to court.
I attempted to pay him. Tri-County can vouch it. First, the lady said, all right, they want to rent.
Do you dispute that you own the money?
No, sir. I'm trying to tell you what happened. I've attempted to pay him. The lady told Tri-County she can vouch on it, she's my confidant, that if I don't stop raising the issue or the problems in the bed book, then that's the only way they accept the money.
So she told you to raise an issue that was not an issue.
No, she told me the issue that I raised, she told Tri-County that if I keep speaking on that, they don't want me there. That the only way they was going to accept the 4,000 that I owe was that I stop speaking on the things that's wrong with the place.
All
The
right.
lady that can vouch is Sharon, who was my confidant.
All right. The information I have concerning your paperwork is that you were treated by Sparrow Hospital on November 16th of 2022. It's a long time ago.
Yeah, but I've been seeing my other doctor at our Forest community.
All right, but that's not that I have a indication that you were seen by for x-rays by David McCants at Great Lakes Medical Clinic. But that's dated May 28th of 2002.
Some of those are requests from the Department of Rehabilitation, because I'm going back to Barber College, so they wanted things to make sure that.
But I don't know how that supports your motion.
Well, there might have been a paper that I just had in there, but here's the paper that I thought I gave them all of his.
I don't know. I've got also another paper out of the year 2000 concerning your hypoglycemia.
All right, here's.
I want a paper that indicates why you weren't here on March 22nd.
Well, I can tell you what the lady told me. She had got personal, and she told the lady at Tri-County that the only way that they were going to accept my payment of the rent is that if I stop speaking about the bed bugs and the other issues that were going on.
Okay, so you decided not to come to court on March 22nd based on what that woman told you?
Well, she didn't tell me that. She told Tri-County that, my counselor there, Sharon. And each time that they would attempt to pay, it would be an argument. I wasn't there, but Tri-County.
I wasn't there either.
I can only say what the lady told me, and I got.
Right. Well, I'm trying to make a decision based on your motion to set aside the possession of judgment based on your fail to appear. That's when the default was granted, because you failed to appear. And you're indicating in your motion that the residence has a bed bug problem. The doctor's statement's attached. I read the doctor's statement. It's almost 7 months old. Okay. That there's dope dealers, trash, and elimination in hallway. There's uncleanness in the building, and that there's, as I see it, a problem brought by multiple dope dealers. This is your motion to set aside the conviction is based on that, but none of that explains to me why you failed to appear on March 22nd.
Since all of the problems that I've had to deal with, that how could I end up in court? And
so you chose not to come to court on March 22nd.
I didn't feel I was supposed to be here, sir.
All right. Well, you were wrong. I don't know how else to tell you. Yeah, you were wrong. You were wrong not to be here. And so I ordered a default judgment, and now you're contesting the default judgment because you're saying I didn't want to come to court and I shouldn't be here.
Based on all the things that I've had to deal with, that I haven't enjoyed basically no time at this place.
Well, maybe it's time to get a new place.
Well, that's what I got a person I'm dealing with now where I can get me a house where I won't have to be bothered with neighbors.
Well,
because I'm going back to college and I don't want to be bothered with these type of things.
Well, how soon can you be out of that place?
I need about 2 months.
No, that's not going to happen. That's absolutely not going to happen.
How much time can you give me to get out of it?
Your eviction. This is staying your eviction. So once I indicate that the eviction is no longer stayed, it'll be the date from the date. It would be one date from. You should have been evicted today. we set this was set on May 5th, ex parte order to stay eviction. And it's set for May 15th. I think you defaulted on March 22nd. So, I mean, you're already past your time. So I'm gonna ask you again, how fast can you get out of the house?
Can you give me 30 days?
I can give you 10 days.
That's gonna be a quick one, but I've already started to pack. I got a lot of things packed up in 2 men in the truck. Try kind of gonna have them assist me on moving.
Mr. Dua, do you have, I know you object to the motion to set aside on default. I don't know what your client, I'm gonna deny the motion, okay? I'm denying the motion to set aside the possession judgment, because you just haven't given me a good reason why you weren't here on March 22nd, right? I know that's what it comes down to, okay? I wanted to hear it to make sure I understood the reason, because it's for a failed to appear. If you were in the hospital, if you had some reason that you couldn't appear, I certainly would say, but your first answer to me was, I didn't believe I needed to be here. Well, that's not an answer, okay? That's really not an answer. So you didn't come because you chose not to come. Well, that's a default judgment. Now I'm looking to Mr. Dua, the plaintiff. We have the stay in eviction. I think he says he can get out in 10 days is fast for him. What's your stance on this?
Thank you. Your Honor, as I know you're well aware, what we're looking for here in a motion to set aside is a good cause and meritorious defense. I for one, without belaboring the subject, don't feel that the defendant has shown either of those, because I would assume, although please recall, I don't have my file in front of me, it seems to me that there must have been personal service in this matter, which means he was served with the summons and complaint in order to get the default on the March 22nd date. So he was actually physically handed the summons and complaint, ordering him.
He had
to come to
personal
court.
service.
Correct, Your Honor. And to me, when that's ignored as an officer of the court, that's a pretty big deal, in my opinion, to not at least call or seek legal counsel or what have you, especially when he has the disposal of Office of Tri-County Office of Aging. It sounds like he's readily in touch with them. Anyhow, that being said, we would stipulate to a 10-day stay and renewal of the order of eviction, or the ability to file the order of eviction on the 11th day, Your Honor.
So, all right. So this is what I'm going to do. So I find there's no meritorious defense. Good cause was not shown. Okay. I'm going to deny the motion to set aside. The default judgment. And we'll grant you 10 days. All right. This is, I mean, we're going back to March 22nd when this was initially, when the initial default. I think that's fair. Okay. That gives you some time to get your stuff, because you don't want the sheriff going through your stuff and taking them out. That's what you want to avoid, right?
In 7 years, I got a lot.
Okay. So with that, it's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. That's the 25th. So
Can I have to the 3rd when I get my check, along with the help I get from Tri-County?
I don't think payment's not an issue anymore. It's just,
well, I need more finance to help relocate, sir.
Your Honor, if I may.
Okay.
Please.
Sure.
Grant him till the 3rd. It sounds like he's on a fixed income, and his money may come in on the 3rd.
So it'd be June 3rd?
Yes, sure.
All right.
Thank you. Additionally, Your Honor, if you could release the escrow back to the defendant in order to assist him further, that would be great.
All right.
Thank you.
I appreciate it.
All right. So we'll make June 3rd the vacate date.
I appreciate that, Your Honor.
And then we will return escrow to the defendant, tenant, which would allow you some money to find a new place.
I appreciate that. I appreciate it. I'm talking to a new landlord that has some housing. So,
All right, so Saturday, so it'll be Saturday, June 3rd.
okay, thank you. Thank you. I appreciate that, sir.
All right, so I've denied your motion to set aside. We've extended the date to June 3rd, 2023. I'm giving you back your escrow money. It's $300 to go towards. So the vacate date is set for June 3rd. I'm denying based on lack of good cause and no meritorious defense, but you have till June 3rd to move out. All right, sir?
Fine.
All right. Anything else, Mr.
I'm
Dewar?
halfway
Nothing
packed
further,
up,
thank you.
That's good. I've been packing up.
All right, all right. Anything else on docket 22-04404, Mr. Dewar?
Nothing further. Thank you.
Where I get that escrow from? Down at the office? Where I put
That's
it?
I think go back to the civil department. I would guess you
It's
go
gonna
back.
take some time.
Yeah, I think you go back to the civil department to make sure they return the escrow. I've written it in the file that the escrow is to be returned to the tenant.
Okay, I'm gonna go down there when I leave out here and see how long it's gonna take.
I'll write it twice just so they see that. All right, you're all set, sir. Thank you for your
Thank
appearance
you
today.
so
Okay,
much. Yeah, Mr. Flores.
correct.
Thank you so much.
You're welcome. All right, Mr. Brown, we'll call your case.
Good afternoon.
So we're on the record in 22-04236 Skyline Apartments versus Laverne Taylor. Will the parties please introduce themselves for the record?
Yes, Attorney Chris Brown representing plaintiff.
All right, this was initially set for 2:45. It is now 3:24. It would appear that the tenant has failed to appear. This is set for hearing on a non-payment matter. I do not see a Laverne Thomas in the Zoom courtroom. I do not see Laverne Thomas in the physical courtroom. Mr. Brown, how would you like to proceed?
Requesting a default be entered for non-appearance for possession only.
Is there any numbers you wanted to place on the record?
Yes, Your Honor. The rent that's now owing through the end of the month of May is $4,785. Court cost $163.82. Total $4,948.82. To the best of my knowledge, information, and belief, the defendant is not a minor in the military or mentally incompetent. And I don't have a calendar on me, so I don't know what the writ date would be.
All right, I think it's May 25th if I sign it today. If I sign it tomorrow, it'd be May 26th, but that would be the May 25th date of signed today. And to the best of your knowledge, the residence was kept in its intended purpose.
That is correct.
All right. And you'll follow it up with an order to that effect, sir?
Yes, Your Honor.
All right. Thank you, Mr. Brown. That's all for record 22-04236. You're all set.
Thank you, Your Honor. Have a good day.
All right. You too. (22-04253). That's Merle McVeigh versus Brianna Aguilar. This was set for hearing today at 3 o'clock. It's now 3:26. Neither party has appeared. In the Zoom courtroom or the physical courtroom, there was a fail to appear from Brianna Aguilar on March 15th. We had service by attachment, so it was set for Zoom appearance from Merle McVeigh, and I don't see him. So at this time, the case is dismissed. And that's all for the record docket 2204-253. I'm assuming they worked. Mr. Kozort, have you had any contact with Miss Al-Shalal?
I haven't received anything since we went off the record.
Yeah, that makes two of us.
Oh, okay.
They're not in a breakout room anymore.
Well,
And
they were both in person. So
yeah, they're in person. We've checked the hallways. Maybe Mr. Klug had another landlord tenant matter that he had to go to, but we lost them somehow.
We lost Mr. Klug too, huh?
I lost Mr. Klug, I lost the property manager, and I lost Miss Al-Shalal. So I was wondering if you'd heard from them.
No, nobody called me, so I was just
all right,
kind of hanging out.
All right, well, stand by and I'll let you know what's going on once I find out.
All right, thank you.
All set now. Just sit tight.
All right, sir, you are Francisco White?
Yes, sir.
All right. All right, so we're on the record in docket 2204-182. That is 917 Chautauqua LLC versus Neil Wright and Francisco. 917 Chautauqua LLC and Neil Wright versus Francisco White. Will the parties please introduce themselves for the record?
Thank you, Hunter. Sam Dua here on behalf of plaintiff.
And sir, once again, you are Francisco White?
Yes, sir.
You can hear me all right, Mr. White?
Yes, sir.
This is a time set for a landlord-tenant formal hearing. All parties appeared on March 1st, and we set it for formal hearing on this date. We reset it once we found out that you, Mr. White, are incarcerated. Would you like to speak to Mr. Dua, the lawyer, to see if you want to resolve this rather than set it to go forward with the hearing?
Yes, please.
Mr. Dua, would you be amenable?
I do, Your Honor, but would you happen to have the iPad available?
Yeah, we do. We can put you on the iPad.
That'd be great. Thank you. My phone's almost died. That's the only reason.
All right, what we're gonna do, Mr. White, is I'm gonna put Mr. Dua, the attorney, on an iPad and let you meet in a breakout room, and then we'll come back and put it on the record, okay?
Okay, thank you.
Thank you. All right, so we're back on the record, docket 22-04182. Mr. Dua, did you have a chance to speak with Mr. White in a breakout room?
I did, Your Honor. I had a chance to speak with the defendant, and we have come to terms on a proposed consent agreement for your review.
All right.
I did also request permission from the defendant to sign on his behalf, and I was granted that permission, but if you could kindly assist with that on the
Right.
record, I would appreciate it.
Mr. White, anything that's forwarded to the court today in regards to the consent agreement, you've authorized Mr. Dua to sign your name on your behalf, is that correct?
Yes.
All right.
May I approach?
You may. And my understanding, this goes as to a consent agreement. And I'll place the numbers on the record. The total for possession judgment is $8,409. The vacate date is May 25th, and the appeal date is May 25th, and partial payment will not be accepted. Is that a fair statement, Mr. Dua, concerning 22-04182?
It is, Your Honor.
All right. Mr. White, is there anything that I've said on the record that you and Mr. Dua did not talk about?
No.
All right. Then for the record, I'm going to sign the consent agreement at the request of both parties. I'll indicate that permission was granted. And I'll sign this on today's date. All right, anything else for the record on docket 22-04182, Mr. Dua?
Yes, Your Honor. I just wanted to put, although it is in the order, I wanted to put on the record that there is no money judgment in this case because Mr. White was concerned about a money judgment.
Right.
So I'd like to just indicate for the record that there is no money judgment prayed for or paid for.
That's correct. There's no money judgment as a part of this. As a matter of fact, box number 7 is checked, indicating there's no money judgment is entered at this time. Okay, sir?
Yes, thank you.
All right. Anything else for the record, Mr. White, on 22-04182?
No, sir.
All right. You're all set, sir. Thank you for your appearance today.
Thank you.
Thank you, Your Honor.
Thank you, Mr. Dua.
We feel like you kind of owe us a Bodie's dinner now. You forced me to give it up.
Right. Yep.
The total rent is $1,099. Court cost $161. Total amount is $1,260. I also am in the general counsel for Lansing Housing Commission. So I contacted my client. There were some issues regarding the moving. We discussed it. Lansing Housing Commission is going to pay $340.28. And they'll cover that. Defendant's portion is going to be $919.72, which we're giving her a month on or before June 15th.
Okay, June 15th. So is that a pay or vacate before June 15th?
Yes, Your Honor. And then if the payment's not made by the defendant, the $919, then can proceed with the application of default, affidavit of default, and immediate judgment and writ.
Oh, and that's a consent judgment you have there.
Yes.
Okay.
So,
all right. And you want me to sign that today?
yes, ma'am.
You may.
I also have the defendant sign the agreement for entry.
All right. Thank you, Mr. Clutes. Okay. All right, so in regards to consent order of judgment, the numbers have indicated for the record are for total rent is $1,216, $919.72 to be paid by June 15th. That was the indication for the record.
Yes, Your Honor.
And the Lansing Housing Commission is to pay the $340.28 of the overage for the entire debt. Is that correct?
That's correct.
All right. And that's your understanding of Ms. Al-Shalal?
Yes.
All right. All right. And so I will sign the order to that effect. Have we talked about anything that you didn't talk about in the room?
Just that last part about the the final default judgment at the end. I mean, it won't not be a problem to have it paid, but I didn't know that it would be a direct, like something set in motion as soon as it was over.
Yeah, it's pay or vacate by June 15th. So if you pay before June 15th, then this doesn't become an issue.
Right. It shouldn't be an issue.
All right, but if it becomes an issue, June 15th is the vacate date.
See, I didn't know that part.
Yeah.
I thought that, well, it shouldn't be a problem, but you never know, things happen.
All right, I think they're going beyond the statutory time.
Yeah, no, I'm fine with that.
Okay.
I just thought you meant what I didn't
All right,
hear.
all
No,
right.
I understand.
You have no objection to that?
No objection
All
at
right,
all. That's
okay.
just the only thing I wasn't
All right.
sure about, but
All
now I
right.
know.
So we've clarified that. You've signed the document.
Yep, I
All
sure
right.
have.
Is there anything else for the record in 2204-222, Mr. Clute?
No, Your Honor.
Ms. Al-Shalal, anything else? Any questions of me?
No, I'm just really grateful to them for helping me and
Okay.
working with me, and you too, Your Honor.
All right. That's all for the record. You can get a copy of the order.
All right, thank you,
Okay.
Judge.
Thank you so much.
Hopefully we're your last one. You get to go home.
You are the last one today, but only by like minutes.
Oh, really?
Because we had somebody incarcerated. So we did that by Zoom.
Okay.
So we were not really waiting.